Okay, in the matter of People versus Eric Martin. Mr. Martin, can you hear us?
Yes, can I get the case number of the so-called case that never was given a copy of the ticket by the police officer, which he should have in violation of my due process right?
2413888 SM.
241, what else?
38 SM.
38?
1388 SM.
24138 SM. Right?
Yeah, 2 weeks.
Okay. All right, thank you.
I do have in front of me a complaint charging with domestic violence violation of city code. It's misdemeanor. Oh, I see, January 24th, January 10th. Okay, you pleading not guilty, Mr. Gazicki?
That's John James Gazicki. Mr. Martin expressed his right not to be represented by a court-appointed attorney. He wishes to represent himself.
Okay. Is that right, Mr. Martin?
Present myself, yeah.
Okay.
Because I don't want to give up my right to be one of the sovereign people, as the U.S. Supreme Court said I have a right to be. So.
Okay. I'm going to let you do that. I don't care why. Have you talked to the prosecutor?
No, I have not.
I want you to get the prosecutor and have her talk to Mr. Martin, and let's see what we're going to do today.
Right, so I would like to talk to him right about how the case should be dismissed based on there's no
chaotic legal universe of Eric Martin, a man who proudly identifies as a living, breathing sovereign being, while simultaneously racking up traffic violations, fighting a domestic violence charge, and attempting to out-argue every judge in the state of Michigan. This intro alone sets the stage for a wild ride. Multiple hearings, multiple judges, multiple charges, but only one Eric Martin, and trust me, he makes up for the missing cast members. As we step into the first hearing, keep an eye out for some of the classic sovereign citizen tactics, demanding case numbers he already has, claiming due process violations for reasons only he understands, and invoking constitutional arguments that exist solely inside his imagination. We'll also see how the courts, calmly, professionally, and with the patience of saints, attempt to navigate his barrage of pseudo-legal jargon. And here's the twist. Not only does Eric refuse an attorney, he simultaneously tries to serve as both defense and prosecution, asking the court to arrest the officer, the judge, and presumably anyone else whose name he remembers. Stay tuned as we unpack the emotional chaos, legal misunderstandings, and dramatic courtroom moments that unfold in real time. This is one you don't want to miss.
Okay, Mr. Prosecutor, want to put your appearance on record?
And good morning, Your Honor. Omar, or good afternoon, Your Honor. Omar Shah on behalf of the people, PA 6332.
Okay. You've had an opportunity to talk to Mr. Martin?
That is correct, Judge.
Been able to resolve this matter?
Judge, there is no resolution on this matter. I had an opportunity to speak with the defendant in this case. He wishes to have a jury trial or a bench trial. He just doesn't know which one he wants.
Okay, Mr. Martin, which one do you want? I'm going to set this over for a trial. You want a jury or the judge to hear it?
Well, I don't really want to answer that question. I don't want to be fraudulently presumed I'm consenting to any of these proceedings. You know, I'm not consenting to have my right against slavery violated by consenting to any proceedings. So that's why I kind of want to answer that question. But before I get to, as I notified the prosecutor, he should have dismissed the case due to lack of evidence. But I had one more thing I wanted to point out to the prosecutor. I forgot to mention to him. I want to mention to him now, and that is I want the police officer, Bardaway, who illegally arrested me. I want him charged for the legal arrest, which is assault and battery. And also Judge Shackelford, who did not give me a personal bond. I want her arrested too for violating my right against kidnapping and allowing this unlawful incarceration of me, which I have a right to do. And if they refuse to do it, I'm also going to move for dismissal on the case because it's violating my right against equal protection, because I have the right to have charges brought against people who have committed crimes against me also.
Okay, based on that, I'm going to indicate that you want a jury trial. I'll set this matter over. I'll have the assignment clerk set a date. She'll send you a notification of the date for the jury trial. In the meantime, I'm going to continue your bond until that day. You go with the sheriff, he'll take care of you today.
Hold on, objection. I have a motion to make that I have a right to a personal bond.
You
I have-
file that motion in writing and I'll take a look at it.
I already
In the
did file it with the.
in the meantime, I want you to go with the sheriff and he's gonna take care of you.
Hold on, object. I have some, I already
Put 'em
filed it
on,
with the
put 'em on
I'm
mute.
making that motion now. I'm making that demand actually now because it's a constitutional right to be
Denied,
innocent without guilty.
denied.
All right, then I'll be taking your job. How about that? Because you violate my constitutional right and I move to dismiss you off the case, disqualify you. Since you violate my due process right to a personal bond, then you showed your biasness and you should not be in the case no more. I move to disqualify you. If you deny that motion, I request that you send it to the State Court Administrative Office. You're not supposed to continue my bond with monetary award. Shackelford illegally denied my personal bond, and you're not supposed to continue that illegal denial. I have a constitutional right to be presumed innocent, and that means the right to a personal bond. Article 3, Section 1, judges that violate the Constitution cannot hold office. But don't grant that motion if you want to, that demand. I'll be to get your job in a lawsuit. That's all I got to say. So you want to continue with that? Sound like they muted me, maybe. Well, these judges are going to find out. They're not above the Constitution.
Demands the case number, claiming he never received a copy of the ticket. This is a classic sovereign citizen move. They try to undermine the court by arguing that procedural errors void the entire case. But notice how the judge patiently reads the number anyway, even though it's already on record and has been provided multiple times. This early interaction sets the tone for what's coming. A tug-of-war between actual legal procedures and Eric's self-created version of the law. Question for viewers. Have you ever seen someone ask for information they definitely already have, just so they can argue about it? Welcome to Sovereign Citizen Logic.
Taylor versus Eric Martin.
Jeffrey Fanto, the court asked me to verify that Mr. Martin would be presenting himself without the assistance of attorney. That appears to be his position, Judge.
All right, so Mr. Martin, you are waiving the House Counsel.
Yes, so I'm not fraudulently assumed to be the defendant, a living man, not the legal fiction corporate entity defendant, which I couldn't possibly be. I don't due to canon law being, unfair. It's you guys fraudulently assume that if I take an attorney. So that's the unfairness why I can't accept attorney because of that.
Sure. All right, and you understand all of your constitutional rights?
I do my best to. I've been studying, practicing law 28 years.
All right, that's all right. So looks like this is ready to be set for a jury trial. Is that right?
Yeah, but I want a jury trial of my peers means of the sovereign people, not U.S. citizen slaves who most probably everyone of the jury probably say they are. So.
And I'll determine that. So we will have this set, and then I'll mail out the date for the jury trial.
I believe there's a date set for next Tuesday for the jury trial in this matter.
All righty, I see that.
I have objections. I cannot probably prepare for trial in this jail. I've been illegally denied my constitutional right to a personal bond, even though it's my constitutional right because it's part of my right to be innocent before guilty. It's been denied so far. I have no money to pay for a bond to get out of here. So that's especially why I also should be given a personal bond. And like I said, I cannot probably prepare for one in here.
So you're in there for a different matter because I set your bond at $100 personal before on this matter. So it's whatever's keeping you in jail isn't this case. So We'll see it. Well, I understand though that you do need to prepare for trial. I get that part. So we'll go ahead and adjourn the jury trial. When is your out date, with whatever you're doing there?
There is no out date. That's the thing. It's so is this about the moped case?
Yeah, this is driving while your license is suspended.
I wasn't sure, right? They got me legally confined right now in the domestic violence, no evidence at all. She lied, made a statement, so now they got.
Hold on, Mr. Martin, hold on. Even though this is a different court and that's not my case, you have the right to remain silent. Anything you say can be used against you. I just want to advise you of your Fifth Amendment right again. So I suggest like not bringing up the other case. This case here is on the moped and the driving on a suspended license, or revoked license.
Okay.
So what I'm saying is you need time to prepare on that one. I don't know what the situation or status is of the domestic violence case, but you said that you're on bond. You haven't posted your bond on that case. Is that what you're saying?
Well, I'm not even sure. I think the judge said a monetary bond. I wasn't sure because she unprofessionally drew the thing away from, you want to call it this, the remote Zoom thing away from the door before I could read to hear. But it's not like she told the police officer $2,000, but I'm not even sure. I got no money to pay a bond, no way, even if it's $1. So,
sovereign citizen philosophy. He rejects legal representation because he doesn't want to be treated as a corporate fiction. This is a recurring theme in these cases, the belief that accepting an attorney somehow traps them in a hidden maritime contract. Spoiler alert, it does not. Meanwhile, the judge stays cool, asks whether he's spoken with the prosecutor, and tries to move the case forward despite Eric's attempts to derail the proceedings with constitutional buzzwords used incorrectly. This moment highlights the contrast between courtroom reality and fantasy law.
I don't have nowhere else to live. That's my house. I'm allowed there. You ordered
these
that
other
is illegal. That violates my due process.
All right. He has a $2,000 cash bond with a GPS tether.
Yes,
And he's not to
my right to a
return.
personal bond.
He's
I have a
not
constitutional right
to
use it.
appear
You can
at
be
9.
innocent without guilty.
He cannot come to 9074 Clifford or be in contact with Crystal Martin.
So, right, because they illegally deny my personal bond, this is why I'm still in here. So, but yeah. So,
All right. So what I'll do is, I don't know when that case is next. The next day, is that it's a state case? Ms. Van Reno, you don't have that case, right?
I don't
so
know
it must
anything
be a
about
state.
that.
All right. And so it must be a state case, which means it's on a Monday. So that's probably going to be resolved within a month. So let me go ahead and set this for jury trial. No, there will be no need to set it for a settlement conference before that. But let's get a date.
I won't catch up. I was going to object before you guys don't give me a chance to talk. I object to like it should be. I moved that to be stayed. This moped case till I get out of prison. I mean, till I get out of jail here. I can prepare myself. I can probably prepare myself.
Right, that's right. Listen.
Access to my legal authorities to argue nothing.
It's being set for a jury trial.
The one
It's
is-
from yesterday.
Okay, so when is that one?
They didn't set it.
Okay. All right, so I'm going to set it for a jury trial, but if you're still in jail at that time, then I'll just adjourn it again so that you can prepare. I'm not worried about that. So, I mean, but I can't do anything about your other case is what I'm saying. So I'm looking at, as far as the date right now, I just want to put a date on the books so that we know that you have an idea. I mean, if you get out tomorrow, then you'll know and then what your date is. So I'm looking at, let's see. And I don't have the availability to check with my clerk because my criminal clerk is out this week.
Your Honor, we do
So
I'm sorry, Judge. We do have other jury trials scheduled on your docket on July 9th. I don't know if that's too soon.
that's probably going to be, it's only a couple of weeks away. So I don't know what his situation is. And even if he gets out in a week, that only gives him a little bit of time. I want to make sure he has at least a couple of weeks to, I mean, it's a driving, it's a driving on a restricted license, so it's not exactly a whole lot of prep time for that. It's not a homicide case, but.
This right here is a dramatic reveal. The judge points out that the alleged victim is literally sitting beside Eric in the breakout room. That's a massive indicator that the case is serious enough to be moving forward. But instead of acknowledging this, Eric insists the entire prosecution is malicious, lacking evidence, and outside the court's jurisdiction. This denial is common in sovereign citizen ideology. Evidence doesn't exist unless they personally approve it, and jurisdiction disappears whenever they say so. The judge calmly pushes forward while Eric spirals deeper into pseudo-legal theories.
13th. Because I'm trying to pick a date that's outside of probably where I'm already scheduling stuff at, because I don't have my criminal clerk here to kind of check and see like where I'm at with things. So we're going to set this for August 13th.
Thank you, Your Honor.
And I know that we'll set that at 8:30 in the morning, August 13th. All right. Mr. Martin, let the deputy know that you're all set, and we'll be mailing out the notice to you, sir.
Thank you, Your Honor. All the best to you and your staff.
Say again?
That's something I want to say to with the prosecutors here. Dealing with this other case that I'm here for now, I request that
not the same prosecutor. Not the same prosecutor. That's the state prosecutor.
They're Taylor prosecutor.
Your other case, are you talking about your other case? Your other case is a state case. So that's a Wayne County prosecutor's office.
No, sir,
not the city attorney.
I'm talking about the case I'm in here now. I want them to notify the prosecutor that I want charges filed on Crystal Martin for bringing these falsified charges against me now. And also for assault and battery that I have on video camera for. Just so, you know what I mean? And she keeps bringing this.
Again, that's the other prosecutor. That's a different prosecutor's office, sir.
Because it's my equal protection right to bring charges too. They want to bring charges against me, but they don't have no evidence. I do. And I should be the one suffering here in jail as a lack of evidence. This is all pride and the unequal protection.
And that's on your other case, sir. So
it's still a right though. It's still my right to tell the prosecutors this and have them act on it. And if they don't, it's going to certify a defense.
This isn't the proper prosecutor. That's the Wayne County Prosecutor's Office on your other case, okay? This is the city attorney. Okay. Deputy, have a good rest of your day to you and your staff.
Thank you, Your Honor.
Thank you, Your Honor.
Here comes one of the most chaotic moments so far. Eric attempts to turn the hearing into his own personal prosecution. He demands criminal charges against the arresting officer and a previous judge. Yes, the judge, for not granting him a personal bond. This is courtroom delusion at its peak. Eric mistakes disagreement with criminal wrongdoing, assuming that if someone does something he doesn't like, it must be unconstitutional. What we're seeing is the sovereign citizen feedback loop. If I don't understand it, it's illegal. Viewers, do you think Eric is sincerely confused or deliberately playing the system? Let me know in the comments.
People versus Martin, case 241388SM. Today's the date and time set for a settlement conference. Also, there was a motion by Mr. Martin, motion to dismiss the case. Court has read through the motion. There was no accompanying brief in support. Well, there's also objections to the denial of the personal bond. I'm going to consider that as a motion for reconsideration. All right, Mr. Martin, was there anything else you wanted to place on the record, sir?
Oh, yes. Well, first, I'm not the fraudulently assumed defendant. I am a living sovereign man.
I can see that you are a living man. You are currently talking, and we are having a conversation. So, okay.
Right, but John, under the law, there's fraudulent presumptions under canon law 3228 that, you know, that say otherwise, and there's a lot of support what I'm saying. That's why I say what I say to, you know, for the record. But Anyways, yes, I do have other things to say. First, I also want to file a demand to dismiss this case based on speedy trial violation under Mission Court Rule 6.04C, 28 days for speedy trial in misdemeanor cases. I've been in jail over that since the 8th of last month.
And here's where the meltdown escalates. Eric threatens to take the judge's job, file lawsuits, dismiss the judge from the case, and everything in between. What's fascinating is how calmly the judge responds. He doesn't argue, doesn't raise his voice, simply tells Eric to file motions properly. This is a great example of courtroom professionalism versus sovereign citizen theatrics. Eric believes that shouting constitutional buzzwords forces legal outcomes, but courts operate on written motions, evidence, and actual case law. Spoiler, yelling. Article 3, Section 1 doesn't override due process.
And also, well, go ahead and also want to say, I ask that you give me all the time to speak, say anything I want to say, instead of like shutting the court proceedings off that's happened before, make sure I'm done with everything I have to say, but that's it for right now. But like I said, I might have to say depending on what you say in response. So.
All right, well, your motion to dismiss is denied. Your motion for reconsideration with regard to personal bond is also denied. Are we setting this for a bench trial or a jury trial?
Before I ask that question, I have to respond now to your denial. Now, based on what reasons are those denied, I have things to say in response to that.
Well, sir, I'm not cutting you off, but there's nothing, it's my ruling. If you want to file a motion for reconsideration as to anything, you're more than welcome to follow the court rule and do so. But there's really nothing to add to